I totally agree, this is an underexplored issue. It is also a complicated issue, as you said it. I would add it's also a fascinating topic. Because when taking that seriously, it really urges us to go very deep into the foundations of human rights, of law, of morality. And we will then discover, when dealing with the foundations, we will also see the limits of what a legal order can provide. So that's why it's a quite fascinating subject, but at the same time also a very practical one. Just a few months ago, I happened to be approached by a midwife from Sweden who is prohibited from practicing in Sweden because Sweden has a very strict understanding of accessibility of reproductive health. So everyone working in Sweden in the health sector is also expected to participate in abortions. She declines, she denies, objecting from conscientious reasons, and thereby, as a result of that, cannot practice in Sweden. She can, however, practice in Norway. So you see also the situation in European countries is pretty different, also in the Nordic countries, who are very often perceived as being very close, but in that respect they are not that close. Okay, now to spend a few minutes pondering the foundations of human rights law. Yeah, we will come across the term conscious as a very important one. It's not just part of Article 18. That's actually my mandate. Freedom of thought, conscience, religion, or belief. You find it in Article 18 of the Universal Declaration, but also Article 18 of the International Covenant on Civil and Political Rights, and other documents, including, of course, regional human rights instruments. Okay, there is part of a broader understanding of freedom of religion or belief. But then on top of that, and that would be my starting point here, you also find reference to conscience in Article 1 of the Universal Declaration of Human Rights. Usually we only quote the first sentence. I mean, the first sentence of that first article is well known. I think most of you will be able to stand up and sing it, yeah? Or at least know it by heart. We can also quote it by heart. And that is, all human beings are born free in dignity and rights. That's a very famous, possibly the most frequently cited sentence from any of the UN documents. But then, interestingly, it goes on, and the second sentence is hardly ever cited. So, all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards each other in a spirit of brotherhood. Oh, I don't like the spirit of brotherhood. I mean, that sounds a bit pre-feminist. But reason and conscience, I mean, what is that? What is that? I think it's closely interwoven with human dignity. Because that was the last word, equal in dignity and rights, of the previous sentence, or almost the last. Because it means respecting human beings, all human beings, in their potential of responsible agency. And that's something we have to ascribe to everyone. We have to respect in everyone. And it has a status even beyond a specific human rights. I would say this belongs to the very foundations of human rights. Even more. I mean, that respect for every human being in their potential of responsible agency is at the foundation of any normativity whatsoever. So not only human rights, but any rights, any legal norms, any moral norms, any moral interaction whatsoever, finally is based on that insight. So it's very fundamental. I mean, nothing could be more fundamental than this. And at the same time, really seeing how fundamental it is, we become aware that the legal order, any legal order, including human rights laws, has limitations that are very difficult to overcome. Because, I mean, the legal order, and now I'm particularly talking about human rights law, but I mean, human rights law also should shape the legal orders in general. They derive their legitimacy from human dignity, from respect for every human being in their dignity, meaning in their potential of responsible agency. Okay, and that respect, that basic respect, is institutionalized in an order of rights. But respecting the potential of responsible agency is not the same thing as adopting the various moral convictions. So, especially in morally pluralistic societies, of course, everyone should be respected as a moral agent. But it does not mean that the legal order, and not even the human rights legal order, immediately reflects and does justice to the moral and possibly also to the deeply held moral convictions of each and every individual. And I mean, so here we are sometimes even confronted with tragic situations. Of course, we are supposed to find solutions, but we should be aware, I mean, it will not ever be possible, not always be possible. I mean, that is really, I mean, the deeper you go, the more you see also the limitedness of human rights in that sense. Yeah. There are limits. Because, I mean, the legal order as such, and that includes human rights law, of course, it respects the conscience, but not immediately respects the conscientious positions as such. I mean, you have to expect discrepancies. You have to expect discrepancies between what a legal order lawfully demands of citizens and what the individual conscience dictates. And now, I mean, taking freedom of conscience very seriously means the legal order, so also societies, the legal community, if you wish to use that term, is responsible for accommodating conscientious positions, including conscientious objections. But it will not always be fully possible. That's very clear, especially if you bear in mind not only moral pluralism, but also the fact, I mean, morality can be, it covers everything. It covers very different areas of human life. I mean, here we will focus on issues like abortion, euthanasia, but it can, if you take it seriously, it can actually cover dietary issues, dress code issues, everything. So the way is how to deal with these discrepancies. And conscientious objection is not the ordinary way of finding a solution. It's the extraordinary way, if I may use that term. So the ordinary way would be in a democratic society, okay, people very often have objections. I'm not fully in full agreement with everything that my government does or with everything that the legislator has legislated. I mean, that is, and sometimes it's even difficult to pay taxes knowing, I mean, it will be used to all sorts of things which I morally object. So the ordinary course would be participate in public discussion. So public discourse in which then people can voice also their moral objections. I mean, that is the ordinary way. And I mean, that's the usual way in which then people, okay, somehow have to deal with that gap or with that discrepancy, trying to bridge the gaps to overcome dichotomies, at least to overcome schizophrenias. Yeah. Okay, and that's why, I mean, conscientious objection is only one possibility, I would say extraordinary, for very specific situations. You cannot apply it to all questions where I personally am not in moral agreement with a certain lawful obligation I'm confronted with. So and when defining, I mean, what are the conditions of that extraordinary option? Okay, that's already difficult enough. I would say it should be confined to situations of an existential veto. Not any sort of moral contradiction, but an existential veto. So doing this, participating in this or that act, would mean I betray myself. An act of self-betrayal, I mean, so it would erode my own understanding of human dignity. My self-esteem as as a responsible agent. And that is, of course, something the legal order can never expect from any person. So the situation of a moral veto, the question is when exactly do we have that? So that's always complicated. It requires communication, and there can be misunderstandings. Again, I mean, we have to expect tragic situations. Then it should also, I think, be, or it's more plausible if it concerns the person very directly. If, for instance, paying a tax from which the military budget is also covered is different from being expected to personally take arms. And yeah, the same, I mean, concerning the medical sector, people will not be fully in line with the health system in general, but then being expected to participate maybe in an act of euthanasia is something very different. So existential veto situation, personal, or the expectation of personal direct involvement, and then yet another condition is because those objecting to do something which is lawfully expected, I mean using the term law now in a very positivistic understanding, they should nonetheless somehow pay respect to also a legal order with which they are not fully in agreement. So the traditional way in the more established military service context is alternative service. I mean the readiness to do some sort of service to the society, which of course cannot be directly applied to the health system, but nonetheless I would say also it's not a possibility to people, okay, leave me alone. That's not a possibility. Now to apply that, and I'm aware we are running out of time, to apply that now to the specific situations of health, people working as professionals in the health service. Some people, or some observers would say, okay, if they sign a contract, it's their own fault. You sign a contract, you do it on your own initiative, it's a voluntary signature. Okay, it's different from a mandatory military service. Okay, it's different. But signing a contract does not mean you can surrender freedom of conscience. I mean, that is, if any right is indispensable, inalienable, you cannot surrender your conscience. Of course, no one would be, no one should be as crazy as to sign up to something that is per se against their conscientious position. But I mean, working in the health sector, broadly speaking, means, I mean, you are accepting most of your professional duties, but maybe there are certain situations in which you would refer to your conscientious position. Signing up to a work contract, to an employment, would not surrender that right. I mean, you cannot surrender freedom of conscience. So it's still there, but then now applying to the criteria just mentioned, from my position would be, here also the health service institutions should try to accommodate. I'm deliberately saying try, because there are tragic situations, we have to expect that. They should try to accommodate conscientious objection, especially in those very sensitive areas. That is an expectation that one can raise also vis-a-vis health service providing institutions. At the same time, those claiming conscientious objection, I mean, they also have to do something. First of all, they have to inform institutions in advance, not only once the situation arises. So duties of information in due time. Then, of course, notifying patients. Just imagine the situation: a doctor advises or is consulting a woman who thinks about abortion. That situation cannot be used in order to surprise the client, the patient, in the last moment. So, apart from the duty to inform the institution in advance, also notification of patients if a conflict arises early on would be another communicative duty. And yet another duty would be also to participate in a functioning referral system. I would include that also in the list of expectations that I have now concerning those objections. And I mean, that is somehow the analogon to an alternative service. So some form of cooperation. And still, I mean, they can, if then maybe even carrying out abortion can be a life-saving situation, and no other doctor is available. There are limits even to refer to the nucleus of a conscientious objection in such a situation. If the person then objects, I mean, then he or she will be confronted with a legal expectation. The legal order has to protect the right to life, the right to physical integrity. It has generally also, of course, to ensure access to health service, including in the area of reproductive health. Yeah? And just to conclude, let me quote from my ex-colleague, so the rapporteur on the right to health, not the current one, with whom I would like to discuss it, but the previous mandate holder on the right to health also made a very clear statement in which he acknowledged that this is an area in which we have to try to reconcile human rights in a complicated, in a complex situation. So let me finish just by quoting Anand Grover, who in his report on Poland made the following remarks. The special rapporteur, so Anand Grover, considers that there is a need for decisive action in this regard. Such action should reconcile the legitimate concerns of health providers exercising their right to conscientious objection. So also please note the language. Right to conscientious objection with the legitimate and pressing interests of patients, which also may be human rights-based interests. So not an easy area, an area in which, as I said, we have to face both the foundations of the legal order and its inherent limits. But I mean, the fact that things are complicated should not prevent us from really mobilizing our imagination to steer a responsible course of reconciling the various human rights here at stake. And freedom of conscience remains an indispensable in also that broader context. Thank you very much. It was a bit long, sorry for that.